All right, let's dive right into this explainer. If you're operating a business in Canada, understanding the legal landscape isn't just some boring academic exercise, it is absolutely fundamental to your risk management and, frankly, your bottom line. The Canadian court system is the primary institution responsible for maintaining law, order, and fairness. It ensures that everyone from everyday individuals to massive corporations operates under the rule of law. So today, we're going to unpack the structure and jurisdiction of Canadian courts. But we're not just going to read a textbook. We'll be walking through this entire system alongside a real-world hypothetical small business as they navigate their way through different legal hurdles. To give you a quick roadmap, here's our agenda for today. We'll start with the foundations of Canadian law, move into provincial and small claims, escalate to superior courts and appeals, hit the top with supreme and federal courts, and finish up with civil, criminal, and specialized systems. Okay, Part 1, Foundations of Canadian Law, the rules of the game. Before our hypothetical business ever sets foot in a courtroom, we really need to understand the foundational rules, starting with a massive key term right out of the gate: jurisdiction. Now, jurisdiction is simply the legal authority or the power of a court to hear and decide a case. It dictates exactly which court can handle specific types of cases or even specific dollar amounts. As a business owner, you can't just march into whichever courthouse happens to be closest to your office and file a lawsuit. A court's jurisdiction depends on things like the geographic area, the subject matter, the seriousness of the offense, and the amount of money on the line. If you don't know a court's jurisdiction, well, you literally don't know where to begin resolving your dispute. It's also super vital to understand where our laws actually come from. Aside from the statutory laws written by Parliament, Canada relies heavily on common law, which is basically judge-made law that develops over time. Now, outside of Quebec, which uses a civil law system for private matters like contracts, Canadian courts use this common law system. And at the very core of common law is a critical principle known as stare decisis. Translated directly from Latin, stare decisis means to stand by decided cases. And I love this because it brilliantly illustrates how the whole system operates. Under this principle, judges rely heavily on precedent, meaning similar cases are decided similarly. For a business, this is a total game changer because it provides predictability. If you're drafting a new vendor contract or dealing with a tricky employment dispute, you can actually look at how courts have ruled on similar issues in the past and reasonably predict how they're going to apply the law to your situation today. Moving right along to Section 2, Provincial and Small Claims, where most disputes begin. Let's anchor this with a story. Imagine a small tech supply company based in Alberta. Things are going great until, bam! A client completely breaches a contract, leaving them holding the bag on an unpaid invoice of $90,000. Now, because of that specific dollar amount, they fall perfectly under the $100,000 limit that generally applies to Alberta's small claims court. Remember when we just talked about jurisdiction? This is it in action. Each province sets its own monetary ceiling for its small claims division. And for our tech business, this $100,000 limit dictates exactly where they need to file their paperwork. And honestly, landing in this division of the provincial court is the ideal venue for our business owner. Small claims court is specifically built to resolve minor financial disputes, unpaid debts, and contract issues just like theirs. It's generally way faster, far less formal, and significantly less expensive than navigating the higher courts. It really acts as the very first contact point for most citizens and businesses interacting with the justice system, letting them settle these financial headaches without drowning in massive legal fees. All right, Section 3, Superior Courts and Appeals, escalating the dispute. But what if our dispute isn't just a straightforward unpaid invoice? What if our Alberta tech company gets tangled in a massive million-dollar corporate lawsuit? Well, then they'd escalate to the superior courts, which possess what's called inherent jurisdiction to hear almost any serious matter. And if they go to trial there and lose but firmly believe a legal error occurred, they don't just have to throw in the towel. The appeals process in Canada operates in a very strict sequence. You climb the ladder, moving from the trial court up to the Court of Appeal for their specific province, and then, potentially as an absolute last resort, to the Supreme Court of Canada. Here is the crucial kicker, though. A Court of Appeal is not a do-over. If our business owner is hoping to march in, bring up new witnesses, or tell their dramatic side of the story all over again, they are completely out of luck. Appeal courts generally do not hear witnesses again. Their job is strictly to review trial records and legal arguments to determine if the law was applied correctly or if fair procedures were followed. It is purely an examination of legal interpretation, not a second chance to argue the raw facts of what happened. Which brings us to Section 4, Supreme and Federal Courts, the top of the pyramid. let's say our business case involves an issue of huge national importance. They might seek leave to appeal to the highest court in the land, the Supreme Court of Canada, located in Ottawa. Now, take a look at the unique composition of the Supreme Court here. There are 9 judges in total, but by tradition, 3 of those seats are always held by judges from Quebec. Why? Well, remember earlier when we mentioned that Quebec uses a distinct civil law system for its private law matters? This composition ensures the Supreme Court has the specialized expertise and representation needed to properly interpret cases emerging from Quebec's unique tradition, while the other 6 judges represent the rest of Canada's common law regions. It's a really smart balance. Now, while we've been focusing heavily on the provincial court pyramid, there's actually an entirely separate structure running right parallel to it, the federal courts. If our tech business was suing someone for stealing their newly patented software, or if they were locked in a nasty dispute over federal taxes or immigration matters, they wouldn't even be in the provincial system. Federal courts specifically have jurisdiction over matters involving federal law, like intellectual property, federal taxes, maritime law, and disputes involving the federal government itself. To summarize everything we've unpacked so far, this table is a fantastic, quick reference guide to the main functions of each level. You've got the high-volume, highly accessible small claims courts at the bottom, handling minor financial disputes. Then you move up through the provincial and superior courts for more serious matters, all the way up through the Court of Appeal, ending finally at the Supreme Court of Canada, whose decisions, by the way, are binding on absolutely every other court listed here. It's a beautifully organized structure designed to ensure consistency across the board. Moving to our final part, Section 5, Civil, Criminal, and Specialized. Different laws, different standards. To truly understand their legal risks, a business owner absolutely has to differentiate between the types of legal liability they might face and the standards required to prove them. This is a massive distinction. A corporate contract dispute like our unpaid invoice is a civil case. The burden of proof in a civil case is the balance of probabilities. In plain English, the judge just has to believe your version of events is more likely than not to be true. It's essentially a 51% threshold. But if our business owner was accused of something like massive corporate fraud, that falls under criminal law. The burden of proof there is beyond a reasonable doubt. This is a drastically higher standard, and for good reason. The penalties in criminal court often involve losing your personal freedom, not just writing a check. But here is a really advanced pro tip for you. Often, businesses can avoid traditional courtroom litigation entirely. How? Through administrative tribunals. These are highly specialized bodies designed to resolve disputes in very specific areas, like labor relations, human rights complaints, or workers' compensation. They perform court-like functions, but they are significantly faster, way less formal, and much more affordable. Honestly, for a business dealing with an employment dispute, navigating a specialized tribunal is usually far more efficient than launching a full-scale, exhausting civil lawsuit. As we wrap up this explainer, we really have to look to the future. Canadian courts are constantly facing challenges like backlogs and skyrocketing legal costs, but they are adapting. With the rapid rise of virtual hearings, electronic filing, and online dispute resolution, it leaves us wondering, how will these digital shifts permanently reshape access to justice for future Canadian businesses? The system is evolving, and staying informed is without a doubt your best defense. Thank you so much for watching this explainer. If you found this breakdown helpful, please remember to hit that like button and subscribe to the channel for more deep dives. See you next time.